And joining us now is Amy Barrett, a law professor at Notre Dame. She also previously served as a clerk for Justice Scalia. Amy, thanks for being with us.
My pleasure.
Justice Scalia was known as a larger-than-life figure on the court. What was it like working for him?
All jobs have been downhill since. He was truly a man about whom it could be said he was the smartest in the room. He was also the funniest. He was a great mentor. He was warm. But that is not to say that he was never intimidating. Before argument, he would have a clerk conference, and the clerks were responsible for coming in to present either side of the case to the justice. And he relished an argument, and he wanted to hear the arguments on both sides. He was not interested in just having us parrot back what we thought he wanted to hear. And there is nothing that will hone your skill in making oral legal arguments than going toe-to-toe with Justice Scalia. It was a great...
Justice Scalia was a prominent conservative. Everyone knows that. But everyone knows also that he was very good friends with Ruth Ginsburg, a prominent liberal on the court. Do you think this is going to be part of his legacy, his ability to find common ground with people he disagreed with?
Absolutely. He was good friends with Justice Ginsburg. He developed a close relationship with Justice Kagan as well. You know, today I think too often people who love ideas think that they can only be friends with people who share their ideas. But that is an impoverished life, and it is not the life that Antonin Scalia led. He had great respect for those whose principles were different than his own.
Yeah, that's such an important lesson. Certainly, I hope people take away. What is the impact now, Amy, to the court now that Justice Scalia is gone?
Well, I think one impact will be more boring opinions. My students love reading Justice Scalia's opinions because they're colorful, they're also clear. Justice Scalia really forever changed the way the court thinks about the interpretation of legal texts, both the Constitution and statutes. Before Justice Scalia was on the court was not very self-reflective about the way that it approached interpreting texts. And even those who did not agree with Justice Scalia really sharpened and formulated their arguments on the other side in response to the ones that he made. Now, some have pointed out in the days since his death that Justice Scalia's influence will not be felt through his majority opinions, and they've pointed out that he wrote more concurrences and dissents than majorities. That's true, but that's a function of the fact that Justice Scalia was not the most senior justice among the conservatives who generally shared his jurisprudential philosophy. He served under Chief Justice Rehnquist and then Chief Justice John Roberts, and it is rare for a Chief Justice not to keep the assignment of a blockbuster case for himself or herself. So Justice Scalia didn't have the opportunity to write as many majorities, but those majorities, justices circulate the opinions in chambers before they're published, and they each have the opportunity to make suggestions and say, I'll join it if you change this. And I think that Justice Scalia had a great influence on the way opinions were drafted. And I think his concurrences and dissents are really where he made the clear case because he was speaking in his own voice for how he thought the Constitution should be interpreted.
You know, Amy, I don't know if you saw the GOP debate, but on Saturday, Marco Rubio suggested that presidents don't nominate Supreme Court justices during election years. You are also a law professor. How valid is that assertion?
Well, it's not. I've seen all of the tallies on blogs, and I have not done the historical research myself, but I gather that there have been 6 in the 20th century and 11 if you go back to the Civil War of confirmations that happened during presidential election years. But I think the question is, what does this precedent establish? And I don't think it establishes a rule for either side in the debate. I mean, if you look back, say, at the 6 that were confirmed in the 20th century in a presidential election year, all but one of those was not confirmed, in a period of united government, where the president and the Senate were of the same political party. And it shouldn't be a surprise that the Senate is willing to push a president's nominees through in an election year when they share the same political affiliation. The one exception to that was Anthony Kennedy, and the one that was confirmed in a period of divided government before that was in the 1880s. And Justice Kennedy, you know, the arguments will be that that situation was distinguishable. The nomination, the vacancy did not arise in the presidential election year. It arose the year before in June when Justice Powell retired. And Justice Kennedy was nominated in November of the prior year. Moreover, he was nominated after Bork's nomination had failed and Ginsburg withdrew his nomination. So the wrangling for the spot, the conversation about the spot, the existence of the spot had been in play for a long time before that. Moreover, Kennedy is a moderate Republican, and he replaced a moderate Republican, Powell. We're talking about Justice Scalia, the staunchest conservative on the court, and we're talking about him being replaced by someone who could dramatically flip the balance of power on the court. It's not a lateral move. And finally, the reality is we live in a different time. Kennedy was confirmed unanimously. So, incidentally, was Scalia. And this is not the time we live in now. Post-Bork, as we all know, confirmation hearings have gotten far more contentious. And so I just don't think we live in the same kind of time. So I think in sum, the president has the power to nominate and the Senate has the power to act or not. And I don't think either one of them can claim that there's a rule governing one way or the other.
All right, very interesting. Professor Amy Barrett, thanks a lot.
My pleasure.